This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about arson and restitution and why a convicted arsonist is required to pay restitution as a way of avoiding jail or avoiding a long sentence. There was a fire at a residential property that destroyed several structures and made nearly all of the owner's personal property unsalvageable. M.W. pleaded guilty to first-degree reckless burning for his role in starting the fire. The trial court ordered M.W. to pay $1 million in restitution. In State of Washington v. M.W., the Court of Appeals of Washington on January 29, 2024, dealt with the issue of restitution. According to the affidavit of probable cause, on July 5, 2021, a fire occurred in Battleground, Washington, involving a structure locally known as the Old Cherry Grove Church, 2 dwellings and a storage structure, all located on the same property. The property was owned by Steven Slocum. The damage resulted in a total loss of the structures and their contents. Within 2 months after the fire, the investigating officer obtained recorded verbal and handwritten statements from 5 juveniles, including M.W., who came forward and admitted involvement in throwing a mortar-type firework at Slocum's property. The state charged M.W. with first-degree arson. On January 5, 2022, the state charged M.W. by amended information with first-degree reckless burning, to which M.W. pleaded guilty on the same day. M.W.'s statement on plea of guilty agreed to pay restitution in full to all victims on charged counts, including dismissed counts and causes. The trial court found that there was good cause to continue the hearing on restitution because there appeared to be a potentially complete loss of property and because Slocum's emotional state was just such that he couldn't testify. The court entered an order extending the restitution deadline to August 4, 2022, and a separate order setting a contested restitution hearing on August 3, 2022. At the restitution hearing that actually took place on September 28, 2022, the trial court took testimony from Slocum and admitted exhibits into the record. Slocum testified his property included a former church in his home, a parsonage house, and 3 separate buildings for classrooms and carports. Slocum purchased the property because it had ample storage space, and he was kind of a hoarder. He had a lot of stuff, and this was an ideal place to have it. Slocum decorated the church with a lot of antiques and completed repairs and upgrades. His collection included a lot of photographs, old Victrolas and Edison cylinder players, and musical things. Slocum also bought a couple of pianos, player pianos, and a lot of slot machines. Slocum kept several items of family sentimental value in his home, such as furniture pieces, photographs, his mother's jewelry box and purse, his father's TV shop's test equipment, and an AGA cook stove. Slocum and his new nephew were in the back of the church on July 5, 2021, when the fire started. Slocum called 911 and was unable to extinguish the fire using a fire extinguisher. While on the phone with emergency dispatchers, he started taking pictures, and the court admitted several photographs into evidence, including ones Slocum took during the fire and after the fire, documenting the damage. State Farm prepared an estimate to rebuild the structures for $999,354.74 and paid only $569,255.85 for the damage to the buildings. Geico paid $7,000 for his truck. The remaining vehicles were not covered by insurance. Courts in other contexts have construed good cause to require a showing of some external impediment that did not result from a self-created hardship that would prevent a party from complying with statutory requirements. The fact that he could not salvage anything from his destroyed home also speaks to the difficulty in cataloging and estimating his personal property losses within 180 days of the disposition hearing. The trial court did not abuse its discretion, therefore, in finding there was good cause to extend time for the restitution hearing. M.W. argued there was insufficient evidence of the value of the items ordered as restitution. Restitution must be limited to easily ascertainable damages for, relevant here, injury to or loss of property. Where the offender is contractually undertaken to pay restitution pursuant to a plea agreement, the offender is bound by the terms of that agreement. When disputed, the facts supporting a restitution order must be proved by a preponderance of the evidence. Evidence supporting restitution is sufficient if it affords a reasonable basis for estimating loss and does not subject the trier of fact to mere speculation or conjecture. M.W. argued for the first time in his reply brief that State Farm's estimate does not make sense, but at another point it estimated loss at over $999,000 and indicated it issued him a check for more than $569,000. The Court of Appeals noted that this argument appears to misread the State Farm documents, which separate the repair costs for the church structure and the dwelling structure, and plainly indicated a replacement cost of almost $1 million for the two. Given the extensive nature of the personal property loss, the amount for which Slocum had insured it provided a reasonable basis for estimating that he had suffered loss in at least the $1 million amount. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog there for free, and you will be given notice of every blog posting, usually 5, sometimes 6 a week. And please, if you found the video or the blog to be of interest, tell your friends and colleagues about the blog and the videos and let them also subscribe. If you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider subscribing for a very small fee to my Substack publication. Thank you for your attention.